So I'm now honored and happy to introduce Professor Postema. Professor Postema is coming from the States, from North Carolina, and he's one of the leading legal philosophers in the United States and the Anglo-American world. He has written extensively, a wonderful book on Jeremy Bentham and the common law tradition, possibly his most quoted book, if I'm not wrong. He has published recently a book on the rule of law, where I understand there is a chapter dealing with these issues we are discussing today. So the best thing I can do now is to give him the floor. Thank you.
Thank you, Indrek and Massimo, for this invitation, and I'm honored to be able to talk with each of you, distinguished colleagues, and others who will soon be distinguished colleagues. I must start with a disclaimer. ChatGPT did not write this talk. Of course, that's what it would like you to believe. So, devices deploying advanced language learning, machine learning, and large language models and the like now can translate large portions of text. They can generate images. They can give remarkably accurate medical diagnoses. They can write music. If you like, you can hear the fully developed 10th Symphony of Beethoven, though he never sketched it. He only sketched it. They can write poetry, they can write fiction, they can write judicial opinions. The promise of cheap, fast, scalable, impartial decision-making and accurate and effective behavioral control has spurred an ever-increasing role for AI in the making of law, in the administration, in the adjudication of law, and its enforcement. Now, critics have raised many problems with this, concerns about this, reasons to hesitate about using these tools, concerns about its built-in opacity, its inevitable bias, invasions of privacy, perhaps lack or invasions of failure to meet standards of due process. They displace workers. They even are likely to displace lawyers. And we have worries about the use of AI for purposes of surveillance, not only by authoritarian governments, but also by liberal and democratic ones. However, my concern here today is different. It's a distinctively rule of law concern. As Professor Torre just mentioned to you, I have published about a year ago, a book on the rule of law, and one of the serious challenges I took to the rule of law came from the enormous advance of artificial intelligence over the last few years. We now hear proposals for a robust and widely developed artificial legal intelligence, and its advocates look for the day, not too far in the future, when computational intelligence will exceed the intelligence of judges and legal officials and lawyers. The future envisioned by these advocates is not one of increased role for AI in the law, but for AI in the place of law, not just supporting decisions, but replacing them. So the rule of law then gives an ideal shape to our concerns, I think. We can ask, and I want to ask, is what AI systems, devices do, is it legal reasoning? Or more generally, can they now or in the future govern and regulate and sustain social order in the manner of law? And if not, and this is the key point, and if not, So what? What's lost if we install AI in the place of law? So let me say a little bit, very, very briefly, about what I understand the rule of law to be, and then we can go on to ask that question. In my view, which I argued at length in the book that Professor Latore mentioned, in my view, the core aim of the rule of law is to temper the exercise of ruling power, to discipline it. And its chosen means is the law. So in slogan form, we might say, the rule of law promises protection and recourse against the arbitrary exercise of power through the distinctive instrumentalities of law. So when law meets rule of law standards, law provides a bulwark of protection for the powerless, limiting the exercise of power over them and providing legal recourse to victims of those who abuse that power, and enabling those victims to, if you will, speak law to power. It also provides a bridle on those who exercise ruling power. They must submit to the law and thus must be accountable to others, subject to their assessment and their sanction. Law can rule only if there are forces that hold those who exercise power accountable to that law and through others to that law. Accountability, then, is the necessary complement of the guidelines that law provides. It also, not only a bulwark and a bridle, it also provides a bond constituting and holding together the political community, giving public expression to what I take to be an attractive ideal of human association together. The rule of law then seeks protection and recourse against the arbitrary exercise of power through law, but it recognizes, notice how I put it, there's the aim, protection and recourse against arbitrary power through law. And that very construction suggests there might be other ways. There might be other ways of achieving this constraint and perhaps disciplining of ruling power. And what the rule of law ideal insists is that law provides not just a useful, perhaps for the time being effective constraint or discipliner of the exercise of power, but it provides a kind of principled basis for treating law as that kind of thing because of the role that law can play in our lives as human beings and in our communities as we try to aspire to and work for a kind of association, a kind of life together that meets important values. So here into this context, our question arises. Does wide-scope artificial legal intelligence offer an alternative understanding of the rule of law, or does it propose in the place of the rule of law the rule of algorithms? That's the issue. So in order to address that, what I'd like to ask first of all is, what is the intelligence, we might call it computational intelligence, like, and how does it relate to what we might call legal intelligence? Right? How are they related? Let me say a bit about legal intelligence first, and then we'll talk about computational intelligence. Legal intelligence, law, is first of all practical. That is, oriented to action. Laws, rules prescribe. They signal things that are to be done and offer reasons for doing it. Secondly, law is a reasoned, we might say, law is a reasoning thing. Law's practical reasoning not only produces output that conforms to rules, it also follows the rules. and in an intelligent way it follows them. It uncovers, weighs, and assesses reasons for action and for choices among available options for that action. These reasons take their content and their force from their place in a constellation of reasons that are intrinsic to the system of law. Moreover, it takes place in and is given shape in the context of the disciplined practice of such reasoning. Thirdly, legal intelligence essentially involves judgment at several points in the decision-making process. Judgment is required, for example, to assess evidence and its credibility and the credibility of those who offer that testimony. Secondly, judgment is required to recognize a proposition or an utterance as a rule. That is something that requires one to follow it and supplies one reason to do so. Third, judgment is required to bridge the gap between the rule and its application to concrete circumstances. To bridge that gap, we don't merely pick an option or intuit a right action, we reason to it. Fourthly, to properly exercise, judgment is required to properly exercise what we might call analogical reasoning, which is very much at the heart of legal reasoning. Judgment is needed to situate the target case in a context of cases that are comparable to it, and to identify a pattern or rule that justifies treating the target case in a way similar to those comparable cases. And then judgment is required to decide what to do. That is, to determine, not once we have determined what the rule requires, we must situate that rules directive in a larger framework of reasons and assess its weight or authority and decide then whether to follow it or not. Judgment at each of those cases, judgment is required. So fourthly, and finally here, legal reasoning has an essential moral dimension. Legal reasoning has a moral dimension. I don't mean that legal reasoning appeals to moral principles or values. What I mean is that those persons who are engaging in legal reasoning exercise judgment are implicated in their practical conclusions. They bear responsibility for them. They are practically liable to other persons who assess their conclusions and their reasoning for them. Compare that legal intelligence with computational intelligence. Of course, being very brief here. First of all, I'm going to mention 5 features, all right? First of all, the basic structures, the basic components of artificial intelligence, of course, are algorithms and machine learning. AI devices take the information we have, they call it data, and generate information we don't yet have. They're trained on staggeringly vast amounts of text. The larger the data set, it's sometimes said, the more sentences fed into the devices, the better the outcome, so it's thought. Secondly, legal devices, AI devices, are often said to make predictions. I think that's a misleading term, a misnomer. Rather than predictions, what AI devices uncover are correlations. Based on statistical analysis of the data that's fed to them, on that basis, they predict, that is, correlate, draw attention to another correlate. Third, natural language processing can be said to use and to analyze legal materials, and now I'll use quotes, quote, predict how judges might decide on cases that come before them. However, we must not confuse this capacity with understanding or judgment or decision. AI devices don't comprehend the texts, they mine them for patterns and correlations. Like espionage, this intelligence brings information that might be useful to us, but it doesn't make decisions, it doesn't deliberate. They generate outcome, they don't make decisions. Fourthly, more fundamentally, computers don't understand the languages that they manipulate. Algorithms put together what contributors to the internet or other sources, what they've written or submitted, without regard to accuracy, reasonableness, or truth. Their mode of reasoning, then, is more of that of a curator or a consolidator of data, that is, of the words and sentences, not of knowledge, or even, strictly speaking, of information. Reasoners, AI reasoners, don't understand or appreciate the facts, norms, and arguments that they might find there. They don't appreciate the world in which these propositions, facts, norms are embedded, from which they draw their meanings. They don't engage in the physical, practical, or legal world in all its complexity. And AI reasoners don't appreciate values. Computational reasoning is, in a sense, single-mindedly instrumental. They are programmed with an end, and that's the only parameter that's considered. In the choice of means, it's a kind of radically truncated practical reasoning. There's much talk in the AI literature of the alignment problem, where AI devices are feared they lack our values, and so they might follow some programmed project or goal single-mindedly without attention to all the kinds of values that might bear on pursuit of that goal. So the thought is, well, what we must do is build in more values. I think that's not the right solution, because the problem is not a problem of aligning the goals with our other values. The problem is appreciation of them, grasp of them, and understanding of them. AI devices don't recognize reasons as reasons. Rather, they do as their algorithms mathematically instruct them. They don't appreciate reasons as the potential justifications or vindications of choice or actions. You can't persuade an AI device, you can only change the algorithm, right? Analogical reasoning, this is the fifth point. Analogical reasoning is sometimes said to have an emergent capacity to be an emergent capacity of AI systems. But I think there are radical differences between AI processes and legal reasoning processes. On the one hand, computational reasoning counts to determine the relevance of similarities, and analogical reasoning evaluates. Legal reasoning relevance is determined not by the number of similarities, but by whether they make practical legal sense. Analogical reasoning requires judgment to situate, as I said, the target case in the context of comparables and to identify patterns that justify treating the target case like those that are comparable. So let me say, in sum of this, registering the weight of an argument and assessing reasons for understanding a rule in one way or another play no part in computational intelligence. Rather, it works from and analyzes traces left by legal opinions, not from rules and standards or arguments. Computational process does not perform legal reasoning tasks more quickly or more efficiently. It does something else. It circumvents them. What we have is simulation, not argumentation. Now, we can use computational intelligence in governance in a number of ways. In the exercise of governing power, for example, we can use it in the administration of justice. Let me take that as an example. Imagine an AI device, we might call him, as in the literature sometimes it is, Chief Justice Robots, right? That produces determinations of legal results, in particular cases by way of some algorithmic determination of what's found in legal texts. There are two versions of this. One version, the AI device produces an output for the case, which then a human judge or court functionary or someone implements. AI supports judicial decision-making. In the second version, the AI device produces an output that is given automatic legal effect without the intervention of human functionary. AI replaces judicial decision-making. Now, in view of all the benefits that of using AI devices for this adjudicative purpose, there seems to be no reason to stop at version 1. Indeed, to do so would just introduce the opportunity for human biases, prejudices, misdirected judgments, and the like. Also, it might seem that the AI device you might think it performs norm identifying, or norm interpreting, or norm applying tasks that ordinary courts perform. Of course, that presupposes the existence of norms. But these tasks would also be unnecessary because for Chief Justice Robot to do its work, in fact, inserting norms into the process would interfere with the smooth operation of these AI systems and risk loss of its benefits of, amongst other things, impartiality, effectiveness, efficiency, and the like. Once again, computational intelligence is employed, but there's little reason within the ideology proposed by and within this proposal of artificial legal intelligence, very little reason to insist on the role of general norms. Now, the benefits of this are great. Maximum clarity and precision, uncertainty and imprecision, and the arbitrariness of general rules is eliminated. Oh, please. I've got a ways to go. There is we can eliminate, for example, the costly process of dispute resolution. Given all this, what we might say is, it looks like computational intelligence is a very different thing from legal intelligence. The question is, so what? What's lost? AI systems don't do what courts do, but just do it better. They do something altogether different. Algorithmic regulation is not an alternative form of legal ordering. It's an alternative to law. But the question is, why not? Viewing the matter from the point of the rule of law, what value, if anything, is lost if we replace government by law with governance by algorithm? To answer that question, we need to look again at the object of the rule of law. The ambition of AI is control of circumstances and of persons. And the aim of rule of law was ordering and tempering power, giving it meaningful and accountable direction through the law. The law is not chosen just because it might be the available and possibly effective means ready to hand. We choose it because it provides us some important constraints on and values served by governing ourselves and having ourselves governed and governing those who exercise power by the law. What's lost? In a word, and way too abstractly, normativity. Let me try to spell that out. Consider the law at the interface between governing power and ordinary people. What's lost when algorithms replace the law? We've seen that governance by algorithm leaves no room for the mode of practical reasoning that's distinctive of law, and hence no room for judgment reflection, interpersonal engagement, or personal decision-making responsibility. These are intrinsic deficits with important disvalued consequences, I think. What are they? Let me mention a few of them. Most fundamentally, what's lost is a form of governance that recognizes, respects, and fosters human agency of those who are governed. Each of the AI forms or uses removes governing from the realm of decision, deliberation, and responsibility. It goads rather than guides. It satisfies desires or preferences by circumventing the processes of deliberation by which those preferences are subject to reflection. Eclipsing judgment and responsibility, by doing so, it treats individuals as objects. So governance of persons is replaced by the administration of things. Secondly, what is lost is a certain kind of advantage that law provides. According individuals a meaningful role in law, especially when it makes costly demands on them, respects their dignity and their membership in a community of peers. AI-dominated settlement of civil disputes and AI-dominated enforcement of the criminal law, for example, provide no opportunity for meaningful participation in the governing process by immediately affected parties. AI administration offers no respect, in this context, offers no respect for dignity. Thirdly, with regard to the connection to the world, AI devices are trained and teach themselves on data that's fed to them. They don't interact with the world in all its complexity, but human beings live in that world. They interact with each other in that world. They shape their choices and plans and projects with respect to that world. Legal judgment engages that world, appreciates its affordances that help them follow norms and values intelligently, and they do so with the aid of norms and values that are sensitive to that world. Contrast, AI devices don't inhabit our world. They're like the anthropologists from Mars. They can mimic our world, but they can't see that world as fitting as a context for understanding the norms that law provides. Also, and this reflects something of what was said by Professor Amato, AI is in a sense radically solipsistic. It has no judgment-enhancing human elements that like empathy and compassion. It can't understand the meaning of certain kinds of acts and the impact those acts have on our lives or on people. It can't understand the experience of subordination to others, or the limitation on one's freedom imposed by others, or the moral insult of violations of one's rights. These personal and interpersonal elements provide indispensable context for proper exercise of judgment, especially in context of mercy or equity. There's also an effect on the law itself. Replacing law with AI systems can impact the law itself. The law affords resources and forums for contesting the ruling power and correcting law on which it relies. Law is argumentative. Its deliverances are corrigible, challengeable. It has resources for self-correction. AI-dominated reasoning leaves no room for contesting specific exercises of power or contesting the alleged warrants for that exercise. AI-directed decision-making entails the loss of resources for correction at the very point where law's general norms and processes directly engage the real world of interactions amongst people, at the point where self-correction is likely to be the most effective. Correction or revision of AI-driven regulation is still possible, of course, but this takes the form of revision at the point of design by experts who are removed from the lives and interactions of ordinary people, and thus the locus of accountability. And therein lies one of the most important differences or losses. The rule of law demands protection and recourse against the arbitrary exercise of power. Its device it chooses is for this purpose is accountability, structured and institutionalized by law. However, in an AI regime, accountability of decision-making is radically different, actually non-existent. The fundamental opacity of mechanisms deployed by AI systems is a major obstacle in the way of meaningful accountability of the systems and those who use them for regulatory purposes. We cannot grasp the meaning of its reasoning, so we find it difficult to call it to account. But moreover, we can't assess the determinations, the output of AI systems in relation to norms and rules and the background principles on which they rest. AI technologies don't act for reasons. They execute instructions. The accountability involves investigating this accountability then involves investigating algorithmic code, public rendering of instructions, rather than an articulation and assessment of reasons. So what passes for accountability in the AI domain is rather explainability. It offers explanations of what is happening and why an outcome occurs. It doesn't provide justifications. It provides assurances of reliability, but not justification. Not acceptance of responsibility. And so accounting replaces accountability. Counting and calculation take the place of offering reasons and arguments. Assurance of proper functioning shifts attention from performance to design, from adherence to norms to assessing the relation between output and instructions. As one commentator put it, that's fine for thermostats, but it's not appropriate for the exercise of power. The problem is not that such accounting is ineffective. Rather, it's the wrong kind. It's not the kind we value when we look to the law as a means of protection and recourse against the arbitrary exercise of power. The aim of accountability is not just assuring reliability, but maintaining and, where necessary, repairing relationships, thereby sustaining and supporting trust. Moreover, by their very nature, AI technologies put accounting entirely into the hands of experts. They can't function as components in a network of mutual accountability that engages citizens and officials, lay people, and legal professionals. So, let me conclude with this. Law as we know it doesn't perfectly realize rule of law values. We know that. Or in some cases, even closely approximate them. But law that does aspire to them, that to meet those standards of the rule of law, offers the resources for doing so, and behind it, a coherent and I believe compelling ambition. To embrace AI in the place of law would put those values entirely beyond our reach, or even our aspiration. That's a high price to pay for efficient and effective regulation. And even if we could be assured that it serves a noble purpose and its distortions can be mitigated and its benefits distributed equity, it's still a high price. Whatever aggregate benefits putting AI technology in the place of law might bring, high-value public goods would be lost. Therefore, it seems to me there may well be an important place for AI in the law, to use it to support decision-making by officials, and to support our actions as citizens in the context of our interactions with others. I have no problem with that. I have a challenge for you, not a conclusive argument. I have a challenge for you to say, is putting AI in the place of law worth the very cost? That's an important issue, a philosophical one, a political one, a moral one. That's the task we need to face. Those are the stakes. Thank you.